This post is about family dispute resolution and mediation style conferences and the differences between them. They are both types of mediation, but there are some important differences. There seems to be some confusion about those differences, which is why I'm doing this post. Family dispute resolution is referred to as Fdr. Fdr was introduced by legislation in 2008, and mediation style conferences were introduced by practice direction and rules of the Family Court of Western Australia more recently. Fdr is undertaken by an Fdr practitioner. Fdr practitioners are trained and registered, but they don't have to be a legal practitioner. Mediation style conferences, on the other hand, are undertaken by either experienced barristers or solicitors or a retired judge. And this is an important distinction between Fdr and mediation style conferences. Another important difference is that Fdr is generally undertaken without lawyers. Now, what this means is that the parties themselves attend the Fdr practitioner to undertake Fdr. You don't need a lawyer to be present. In fact, the whole point of Fdr was to give the parties an opportunity to resolve their matters without lawyers. Of course, by request, Fdr can also be undertaken with lawyers. This is an important difference because mediation style conferences are undertaken with lawyers present. You can't have a mediation style conference without both parties being represented by their lawyers. Having the lawyers present is an important part of the process of having a mediation style conference. Both types of mediation can deal with children and financial issues. However, the important difference is that Fdr is compulsory in relation to children's issues only, and whereas mediation style conferences are compulsory in a sense in relation to financial issues only. What I mean by compulsory in relation to Fdr is that if you intend to file proceedings in the Family Court of Western Australia in relation to children, then you must have undertaken Fdr. When you file your court application, you must file with that court application an Fdr certificate provided by the Fdr practitioner that certifies that you've undertaken or attempted to undertake or that your case isn't suitable for Fdr. If you don't file the Fdr certificate with your court application, then the court will reject the documents for filing. And so this is a very important distinction. The exception, there are some limited exceptions to the requirement to undertake Fdr. If you come under one of those exemptions, then you can file an Fdr exemption form, but the court takes Fdr very seriously and it will scrutinise the Fdr exemption very carefully. If the court isn't satisfied that the case comes within one of the exemptions, then the court application will be rejected. Mediation style conferences, on the other hand, are compulsory in a different sense. You can still file an application for financial matters without having undertaken a mediation style conference. The case will then be programmed to the first return date, which is a procedural hearing normally, and at the procedural hearing the court will ask the parties why they haven't undertaken a mediation style conference, and then the court might adjourn the case for the parties to attend a mediation style conference. So in a sense it's compulsory because the case may be adjourned if the parties haven't undertaken a mediation style conference, and then the parties will have incurred the cost of commencing court proceedings, with the result being that the proceedings are then adjourned to subsequently attend a mediation style conference. If the court thinks that the case isn't suitable for a mediation style conference, then the court will program the case to a conciliation conference, and in those cases the mediation style conference is not compulsory. Usually the factors aren't limited per se, but usually it's a result of one of the parties not being represented. Both parties must be represented to attend a mediation style conference. In terms of the success rates of family dispute resolution and mediation style conferences, there are no statistics available at present that I'm aware of, but the success is largely determined, in my opinion, by the quality of the FDRP, that is by the family dispute resolution practitioner, and by the quality of the mediator that the parties obtain in relation to the mediation style conference. It's very important that you select the correct mediator so that you get the best chance of reaching a resolution of the case. So if you're thinking about mediation, if you're thinking about going to FDR, if you're thinking you come under one of the exemptions, or if you're contemplating attending a mediation or a mediation style conference, it's very important that you get expert family law advice so that you understand what your options are and that you put yourself in the best possible position to reach an agreement with the other party.